Welcome and thank you for standing by. At this time, all parties are in a listen-only mode until the question and answer session at the end of today's conference, at which time you may press star 1 on your touch-tone phone to ask a question. I would also like to inform all parties that this call is being recorded. If you do have any objections, please disconnect at this time. I would now like to go ahead and turn today's call over to Ms. Melissa Grosso. Ma'am, you may begin.
Great. Thank you so much, and good afternoon. Good morning to everyone on the call. Thank you for bearing with us while we were working on some technical issues. We're pleased to have everyone here with us for our webinar on destination control statements, which is a continuation of our 17-part webinar series being sponsored by the U.S. Department of Commerce. As you can see on the screen, we have a good number of webinars still to come, so I encourage you guys to sign up for those if you haven't already. And I'd like to thank our speaker who's back with us, Alfredo Fernandez, who's an associate with Shipman and Goodwin. As folks on the call may be aware, there have been some changes starting in late 2016 with the destination control statement, so Alfredo is going to walk us through what those changes are and some of the ramifications for U.S. companies. So Alfredo, I'll turn it over to you.
Thank you, Melissa, and I'll echo the good morning and good afternoon to the audience today. I'm happy to be back with this group for another webinar installment for this summer, and we'll jump right into it. As Melissa referenced, we had a little technical difficulty, so I can't actually get into the web conference, and Melissa's going to control the slides for me with my audio cues here. So, Melissa, after the title slide, we'll go right to the one that starts Purpose of Webinar.
Perfect. Thanks.
So the point of this one, which is a pretty narrow scope in the broader schedule for the summer webinar series, is just to focus on a couple sentences, and that's it, and how it impacts shipping documents and your export compliance program. So it's a pretty narrow scope. We'll get into the details, but first we'll lay a little background as to why this was changing in the first place and how you can go forward using the new language going forward. So the destination control statement is, not surprisingly, just a statement intended to control the destination of your product, your tangible export. You put it on a box with the appropriate type of shipping paperwork, airway bills, commercial invoices, etc. There is some required language for some exports to have this statutorily or regulatorily required statement on there, so that when someone reading it sees it, understands it's controlled under U.S. export laws to a certain extent and acts accordingly after or during the export. So we'll address the new language going forward and how you use it in your own business. Next slide. Just wanted to lay out the timeline because this is fairly recent, but not, breaking news. So it's been around for about a year. Congress, pursuant to its rulemaking process, puts a proposed rule out there, takes industry comments, and then publishes a final rule based on some of that feedback. So that was all happening last summer, and they gave a window of 60 or 90 days, whatever the August to November delta is, on when that rule would become effective. So as of last November, this rule has been in place, and hopefully you have been using it. Or if you are thinking about exporting for the first time and you're looking at these requirements for the first time, this is a good seminar for you. Or if you are switching from EAR 99 exclusive shipments that we'll get into more detail don't require this type of statement, but you're moving into other ECCNs or anything on the ITAR that would require the destination control statement, again, this is a good place for you. So just as a lawyer, I have to give you a little bit of the legal landscape. It's a requirement. The International Traffic in Arms Regulations, as many of you know, if you've been on earlier webinars or are in the exporting business, control military items and technology. This is all under the Department of State, and specifically their DDTC, the Directorate of Defense Trade Controls. The ITAR regs are quoted here in 22 CFR, and I did highlight in red here for you in case you want to read the exact regulatory provision of the destination control statement at section 123.9. We'll have the language in there, but if you're relying on it and want to make sure you get it right, definitely go check the latest statute to make sure you're working from the latest copy. Similarly, the EAR is the other major export control regime. This handles some of the less sensitive military items that have recently come off the ITAR, as well as commercial and dual-use goods and technology. A lot of you will exclusively deal in EAR, and if you're not doing military, won't even have to worry about ITAR much at all. Conversely, this one's run by the Department of Commerce, the Bureau of Industry and Security specifically, and again, the destination control statement is here, cited at 758.6, and I'm glossing over a little bit of the basics on the assumption that most of the audience is familiar with the ITAR and EAR, but if you want to see exactly what the destination control statement requirements are, you have the two citations there for future reference, and you'll have the slides and a net replay of all this presentation if you need it down the road. So, pardon the huge block of text here, but this is part of the problem that was getting fixed. Before, we had an ITAR destination control statement, we had an EAR destination control statement. Industry was confused on which one to use. What about shipments and boxes that have both ITAR and EAR? The regs don't seem to be complementing each other and potentially conflicting. So you don't have to read this one word for word, but I do want to point out that it is specific to the Department of State. That's called out in the language there itself, which disappears in the new version, which we'll get to in a little bit. And we had some common complaints that items being shipped under ITAR weren't really requiring approval from the Department of State. So these were just industry problems that were making their way back to the government. Conversely, the EAR DCS language, the old one, was a lot shorter, but again here, it specifically calls out the EAR as the controlling regulations, adding trouble for when shipments have both, and it's specific that these whatever technology was being sent was exported from the United States that may not even apply if something is being shipped from a foreign location to another foreign location. So it was unnecessarily narrow for purposes of the export control goals. So anyway, that's where we were, and we'll get to why we're moving into a new DCS, or have already moved into a new DCS. So as I mentioned early on, the whole purpose of this destination control statement is to have some indication for your recipient that receives the package to inform them this is subject to U.S. export controls. I need to check what that means for me and this particular item. So that's one motivating factor of what is the point of this, and let's not forget that. That's boxed in on the left there. On the right box, on the motivation for change slide, I'm sorry, Melissa, I've forgotten to have you move. The export control reform process that started a few years ago and has been on a rolling basis making changes to both the ITAR and EAR, in many cases to make common provisions as uniform as possible and complementary and not overlap unnecessarily. So they've been harmonizing definitions, which we'll get to in a little bit, and to the extent similar and related concepts were present in both sets of regulations, they've tried to make them as perfect as possible with respect to the other. And as I've mentioned a few times, industry was a little confused as to how to use the right DCS. So these three factors all kind of culminated in the need for the harmonized destination control statement that came to fruition last year. So that was a little bit of dense history as to why this is happening, and we're going to move into what it is and how to use it now. So I do want you to take a second while this is on the slide, the new DCS language slide, Melissa. Give it a quick read as I'm speaking. You'll notice that it only reflects U.S. government U.S. laws and regulations. It doesn't get specific as to Department of State, ITAR, Department of Commerce, EAR. So it's a generic destination control statement that can be used for both ITAR and EAR shipments. So when your regs say include the DCS, these words, verbatim, are what need to be present on your paperwork. And again, it's capturing the same spirit that reselling, transferring, re-exporting, etc., should only be done with approval or authorization and in compliance with U.S. law. Now, the next question is, where does this thing go? I send a lot of papers with my shipments. Is it on the outside of the box, inside, on the piece itself, whatever? Before, the government did not have a specific location. Now, they, just for simplicity's sake, they picked one common form and said it has to be on your commercial invoice. That is now the rule. That should help unify or make uniform where people know to look, that foreign vendors, as they get trained, or foreign customers or distributors know, I can look at the commercial invoice for the destination control statement, and it should be there. On the other hand, enforcement agents or customs personnel will know that I only need to check one document now just to confirm and verify that they're compliant with the DCS. So it's important that's where it goes. There's really no harm in putting it on another document except for consistency or if something changes down the road, but it doesn't need to go on your airway bill or bill of lading that in the past we know companies have used that type of document as the location for the DCS. And really this commercial invoice, based on some panels and webinars put on by the government as this was rolling out, was just to pick a form that was likeliest to flag the intent for the ultimate consignee to know the item in question is subject to U.S. export controls. On the next slide, Melissa, those that don't require the DCS, so there are a few types of exports that do not require this DCS at all. For example, non-tangible exports. From the prior webinars or just your other training, it's very easy to export in a non-tangible way with transfers of technology or technical data on email and phone calls and conversations and inspections of parts and things that don't go in boxes and go through the mailing system. In this case, the DCS really is a tangible export type of requirement. If you're not putting it on a truck as a shipment, it's really not too much of a concern for you. However, if you are sending shipping paperwork or copies of that, for example, the commercial invoice is being emailed in addition to being included in the tangible export shipping container, you want to make sure it is compliant, because you don't know if your customer is going to just print off the electronic DCS and move that forward, or take the real complete one. So if you're sending a commercial invoice, even electronically for a tangible export, you want to make sure it's compliant with the DCS rules. Now on the second bullet, you'll see exports of EAR 99 items do not require the destination control statement, and generally speaking, that's because EAR 99 products can go to almost every country in the world without a license, with some exceptions, such as embargoed nations and prohibited end uses, etc. But generally speaking, EAR 99 is not too much of a re-export and diversion concern, so the government has made it clear EAR 99 items do not require destination control statement. Now, we'll get to this in a few bullet points here, but just because an EAR 99 item is in the box doesn't mean the DCS requirement goes away. And we'll get to that in a second. In addition to the EAR 99 relief, there are a couple, specifically two, BIS license exceptions under the EAR that if you qualify for the GST gift or BAG baggage exceptions, you also do not need a DCS. Again, these are generally exceptions available for low sophistication, somewhat low value gifts or items. So the government is not as concerned with diversion and re-exports for those types of items and give you some relief there. And as I mentioned before, it's going to be the highest regulated item in terms of export classification that's going to drive the DCS requirement or not. So if you're mixing a shipment with EAR and ITAR and EAR 99 items, the most restrictive piece in that box is going to tell you what your DCS requirements are. As I mentioned before, throwing an EAR 99 pencil in there is not going to relieve your DCS requirement. So the next slide is specific to ITAR items. Kind of on that note, in terms of the most controlled and highest driver in terms of DCS requirements, ITAR requirements are going to need 3 additional pieces of information on that commercial invoice that are going to be placed right near the DCS. And as you'll see in the 4 bullet points, you have to list the country of ultimate destination, the end user, the licensor approval number, or if an exemption applies, you cite the exemption, the regulatory section, and then you add in that language from a few slides back, the full DCS paragraph. So for ITAR, you have to add a little extra icing on the cake there. There's on the next slide, Melissa, there's a couple extra considerations for EAR commodities that are shipped under an ITAR authorization. This is allowed under the sections I list on the bottom slide there in sections 120 and 123 of the ITAR, that sometimes it just makes logistical sense to get ITAR authorization for EAR products if they're used in conjunction with an ITAR product, etc. In that case, the U.S. exporter has to provide the EAR classification and ECCN number in there with the ITAR information and destination control statement, even EAR 99. They just want to make sure the recipient knows this isn't only just ITAR. Here's the ECCN number for other pieces, or even EAR 99 if that applies. Okay, and shifting gears now on the next slide to those 500 series or 600 series for space products and transitioned ITAR products in the 600 series. Those and only those with respect to the ECCNs must be, the DCS must be supplemented with the ECCN itself. So you would have the DCS language and a line right above or below that says ECCN 9A610.x or whatever it might be for your particular shipment. And these are just more sensitive in the eyes of the Commerce Department, are slightly more controlled than the rest of the EAR. So making that clear for your recipient and end user is an effort that the government thought was worth codifying. But not too heavy of a lift. You take the ECCN, you should already know, and make sure it's right there next to the DCS. Now, slightly outside of the scope of the DCS itself, as I mentioned, the State Department and Commerce Department have been harmonizing sections where they can. And there was a big definitions update rule in around the same time in 2016 where both agencies made a concerted effort to harmonize terms that were pretty much trying to say the same thing but had distinctions in language that were confusing the industry. Some of those definitions, which, I mean, it's probably 20 or 30 actual terms that were redefined between the two of them, some are more important for the DCS topic than others. So I'm only going to hit a few of them over the next few slides, but for your own education, go and see what definitions were changed last year, can be a very useful exercise for you. Or checking the latest copy of the regs. They'll already be baked in there. So export, as I mentioned before, can be a lot of things. And I'm only listing subsection 1 here of the definition for export that now applies to both the ITAR and EAR very cleanly. Applies to both, and that's an actual shipment or transmission, including the sending or taking of an item outside of the United States in any manner. Now, there are about 4 more sub-bullets to that section, including deemed exports and things like that, that, as I mentioned for the DCS topic today, don't really apply because they're not tangible exports. Similarly, the term re-export is now harmonized and applies to the DCS in terms of tangible re-exports. And in this case, this definition, and specifically this part of the definition, applies to both the ITAR and EAR. And for those where re-export might be a new term or you've heard it and don't know exactly what it means, it's shipping something from one foreign country to another. So, for example, if a U.S. exporter ships something from the U.S. To France, and then from France it goes to Germany, that France to Germany leg is considered a re-export. That destination control statement should help in helping that French, control or a controlling entity determine if there's some kind of U.S. requirement before it leaves France. And similar but different. There's a term called transfer in country that's used in the EAR and retransfer that's used in the ITAR. They have different terms for the same concept, and they tried to harmonize that, and it turns out they could not. But really that means changing ownership, but within the same country. So the U.S. exporter ships something to France, and French company A sends it to French company B. Doesn't leave France, and it's just considered a retransfer if it's an ITAR commodity, or a transfer in country if it's an EAR commodity. Again, the DCS is intended to educate French company A if it's allowed to do that. And obviously it isn't the complete answer for anybody, but it is an indicator and a reminder for a foreign party to think twice before transferring or re-exporting anything. All right. So implementing the new DCS, Melissa, that's the next slide. We've seen the new language. We've seen where it goes. We've seen how the definitions affect it. We've seen how the mixed shipments will get a slightly nuanced language added to the DCS, like the ECCN, the ITAR category, the destination country, etc. But now you, as exporters, need to figure out how is this going to affect my business, or how has it already affected my business and caused me trouble, or hopefully it was an easy transition. So the next few slides, and this will actually wrap up the presentation, and we'll open it up to questions if there are any, will be things to be considering as you are taking this new language and building it into your business processes. And I'm not an exporter myself. I'm a service provider. So you guys are going to have more insight into how am I going to work with SAP and how I print my commercial invoices, this consideration and that issue. So I'm happy to hear questions there. First step, really, and it's more than just a DCS implementation issue, is really understanding which regulations you're operating under. Maybe you are exclusively under the EAR. Maybe you're a defense contractor and, frankly, only working in the ITAR world, or a mix of both. Or I only do EAR 99 items, and I'm never going to have to put a DCS on any of my paperwork. Another consideration, though, in terms of general export compliance, is your supply chain's compliance. Do you have other U.S. locations that are exporting? Do you have foreign affiliates that are exporting or re-exporting on your behalf, or outsourced manufacturing? Understanding how that whole system is working in the shipping sense for DCS compliance specifically today but export compliance generally on all other days is an important step for your organization to assess. And then lastly, I always remind folks that documentation and record keeping are huge, because should a visit from the government occur, sometimes they're friendly, sometimes they're less than friendly, you want to make sure your file for a particular transaction is complete, shows good faith efforts on complying with the rules. The copy of your commercial invoice, for example, shows the DCS was where it's supposed to be, and your customer screening results are in there and all that kind of stuff. So taking that high-level export compliance kind of internal assessment is a good step in figuring out how to plan out this DCS change specifically. A couple other considerations to keep in mind. Are your products facility specific? For example, only my Tennessee facility ships to foreign countries, or only my Texas facility does ITAR work. Understanding how each of your multiple facilities does its business, and if the regulations and ECCNs and ITAR categories and customer base are unique to some specific facilities, you can tailor how you're going to implement this rule or confirm you've implemented it correctly already. And like I said, hopefully you can take advantage of the relaxed requirements for EAR 99 items and the EAR exceptions, the GFT and the bag exceptions that I referenced earlier. You know, they're there to lighten the load for unnecessarily, bogging down industry. So feel free to use them if appropriate, but there are limitations, as I mentioned. So one of the biggest questions is, the business systems. Understanding, potentially we have some export compliance professionals that aren't in sales or contract review or shipping, but understanding how your commercial invoices are generated as the export focal, whether that's one of your many hats or your only hat, is an important consideration to understand. And working with people who are generating the commercial invoices and making sure they're trained on this new language and making sure it gets in. The configuration of the software for the DCS is another thing you have to understand. Is it tied to the ECCN or classification that gets entered into your SAP system, if that's what you use to pull together information for orders? Does the computer know if this is exclusively EAR 99, I don't need to print this on the form? Does the computer know if this is an ITAR thing, I have to add these extra 3 pieces beyond the DCS language itself, and am I going to prompt the user to fill it in? Do I have a hard stop that will prevent a commercial invoice from going out without the appropriate information that would be required for the DCS? Maybe that's a simple logic, software logic thing that can be addressed. Maybe based on your system, it takes a lot more work to get it up and running correctly. And on the similar note, in addition to you training yourself as export compliance folks, you want to make sure your various departments and teams are trained on the new DCS. They should be aware that it probably needs to be on at least some of their shipping paperwork, and this could affect IT, the shipping wells, sales department, contract review, whoever it may be, quality control. They need to know it exists. They need to know it's changed. It's not the same as it used to be 5 years ago, and that there is some variation depending on what goes into the box there. So understanding where the process controls are, and if you can build in some hard stops in the workflow just to confirm everything's going to plan and in compliance with the rules. These are the things that you should have been doing and can continue doing on a rolling basis, just to make sure the DCS portion of all the export challenges is being met. And as my final slide here on due diligence, and this may be the hardest part, is working with your distribution chain, if you have one. For example, you send a build to print spec to a company in Poland. and you ask them to ship the finished part right to your customer in China, understanding the kind of the compliance status and health for that particular vendor, whether they are affiliated in a corporate relationship or really it's a third-party relationship, is a step you need to take. And it can be very complicated and expensive and time-consuming if you have a lot of these relationships, but it is a step the government expects you to have taken, scaled obviously to the size of your own operation. And then working with your customers. Obviously there's a sensitivity to keep your customers happy at virtually all costs, but you need to be comfortable that your customers are appreciating the limits on diverting U.S. origin products. And in many cases, it's okay to ship it to another country. In many cases, though, it is not. And working and helping train your customers is a sometimes uncomfortable but nevertheless required expectation of you as a U.S. exporter. And helping along those lines are things like end-user certification documents and going back and forth with them on what is appropriate for this particular shipment or for all shipments, and help them understand what rules they walk into by accepting U.S. exports. And then, of course, this is a general guidance that can be applied to every aspect of exporting is your understanding of the product, the destination country, where is this thing really going to land? Who's going to be controlling it at the end of the day, and what will it be used for? And that's an exercise that impacts you as the exporter, your distribution chain, your vendors, your customers, your freight forwarders, et cetera. If you really can't answer those questions very completely, you need to just take a step back, assess based on your risk profile, are you okay with not knowing the exact answer for every shipment? And that's a case-by-case type assessment. But those are four questions that I always remind clients are important to understand at every stage of the process, for every shipment, for every transmission, et cetera. So that is the end of my presentation. I'm happy to take additional questions. And as I said, I was not able to log in. There was a system error for the e-conference, so a lot of times I see typed questions come in. Unfortunately, I was unable to see those, so I'll ask Melissa and our operator to lob any questions that did come in over orally, and we can address them as needed. And my information is on the first slide of the presentation that Melissa and the commercial service will send around. So emails are absolutely okay after the presentation if there's a one-off question that we don't get to today.
Great. Thanks so much, Alfredo. Appreciate you sharing this great information about the DCS. As a reminder to folks on the call, if you press *1 and record your name, you can ask Alfredo a question over the phone lines. We did, Alfredo, have a question come in over the queue. In this particular scenario, this gentleman is working with non-U.S. coworkers, and they frequently exchange documents falling under 9E 991. They generally include a destination control statement on the title page of their documents. The question is whether this is still required.
If your technical data should be marked as, for those potentially unfamiliar with the 9E991 ECCN, it's technology controlled under the EAR for aircraft, and as a general matter, technical data should be marked or stamped with the appropriate ECCN, and on the assumption that your coworkers are from nations that would not require export licenses. Strictly speaking, the destination control statement does not apply to an intangible export. But like I said, the exact DCS language does not have to be in there because there is no commercial invoice, presumably for the transfer of that technical data. In a scenario where your customer is paying exactly for that, printouts of the technical data, you start blurring lines as to what the commodity is and what the technology is. But generally speaking, all your technical data should be appropriately marked and have some kind of language in there as to compliance with U.S. law. It just doesn't have to be the exact words of the destination control statement that is reserved for tangible exports.
Great. Thanks, Alfredo. And operator, have we had any questions come in over the audio queue?
We did have a question come through from Judy Myron. Judy, your line is open.
Hi, I have a question regarding the end user. A lot of our customers will ship them their part after we overhaul it, but as far as the end user, they don't really always know who they're going to sell the part to.
Yep, and that's a tricky issue that a lot of exporters deal with on a daily basis, and you're not alone. I know that for sure. To the extent your due diligence is sufficient for the particular risk profile of that transaction and that foreign customer, if it's very clearly a dual-use part and they're keeping them in inventory for any customer that comes into the door and may want to buy that particular piece, the risk goes down a little bit because it's not expected that you would know what their next 300 customers are going to look like. If, for example, due diligence would clearly indicate that 80% of their business goes to the Chinese military, and you're dealing with an ITAR or some particular EAR controlled parts, then even though you don't know exactly where it's going, there's enough red flag material there that you should do a deeper dive into what kind of customer is likely to receive that at the end of the day as the end user, even if it's not the exact entity you can pin down to one company and one address, for example.
Okay, thank you.
Thank you, and I'm showing no other questions from the phone line at this time, but again, as a reminder, it is *1 and record your name.
And while we wait, Alfredo, to see if there are any other questions, did you have any final thoughts that you'd like to share with the group?
I think we exhausted this topic quite thoroughly, but I do encourage you for the upcoming webinars. There's a bunch in the next few weeks. I think my schedule shows one for the next 3 or 4 weeks every Thursday or something like that. There are some juicy topics in there. A little more of the 101 basics are still left, but we're starting to get into the quote-unquote 201 group of webinars that for those already familiar with exports with very detailed questions on nuanced topics, having these available over the next few weeks for the easy 1 hour, 90-minute dial-ins is a great resource for you, and I encourage you to take advantage of it.
And operator, we'll do one final check for questions.
I'm still showing no questions from the phone line.
Okay, great. Then, Alfredo, I'll thank you again, and thank you in advance for as you mentioned, presenting on a bunch of webinars we have coming up over the balance of the month and early next month. So we look forward to speaking with you all again next week. Have a good afternoon. Thank you.
Thank you, everybody.
Thank you for your participation in today's conference. You may now disconnect at this time. Have a wonderful day.